Now we are officially live. Okay, good morning, everybody. Good afternoon to some of you. Welcome to panel 1 of the 4th International Conference on Access to Legal Aid and Criminal Justice Systems. My name is Holly Hobart. I'm a Senior Program Director at the International Legal Foundation, and I will be the moderator for this panel. I'm going to start with a few administrative announcements. First, this webinar is being recorded and may be shared on social media. Second, regarding interpretation, we are very excited to offer live interpretation for this panel session in Burmese, Dari, and Nepali. Burmese will be on the Chinese channel, so if you go to the interpretation button at the bottom of your screen, the Chinese channel will actually be for Burmese translation. The German channel is for Dari, and the Korean channel is for Nepali. So we will hopefully everything is going okay with the translation already. And if not, please go ahead and type something into the chat regarding that. So that's the next administrative announcement, is regarding the chat function. We do invite you all to introduce yourselves. We have many participants from around the world. This is primarily an Asia panel, but we, throughout this conference, have representatives from over 75 countries. And so one of the main points is to share comments and communicate with each other. So that chat function can be used for comments. If you have any questions for panelists specifically, substantive questions regarding the session itself, then I would ask that you enter those into the Q&A function, which is a different button at the bottom of your screen from the chat function. If you need to ask a question in Dari, Burmese, or Nepali, you can actually do that in the chat. And we have some people monitoring the chat who will be able to translate those questions into the Q&A. Time permitting and technology permitting, at the end of the session, I do intend to leave a lot of time for questions and comments, and I hope that you will be able to actually voice your own comments, and so we'll walk through that process at the end, but for the time being, please do type in any questions that you have. By default, all of the attendees are on mute to ensure a smooth webinar without any background noise or distractions. So the organizers can unmute participants during that question and answer period. This event, we do have to thank our hosts. It's being hosted virtually by the Public Defender's Office of the State of Rio de Janeiro, together with the International Legal Foundation, the Open Society Justice Initiative, the United Nations Development Program, and the United Nations Office on Drugs and Crime, in collaboration with the government of the state of Rio de Janeiro, the National College of General Public Defenders of Brazil, the Public Defender's Office of the Union, and the National Association of Public Defenders of Brazil. So, without further ado, it looks like we have several participants who have joined us, and I think we can get underway. The theme of today, this first day, is advocating for release and protecting the rights of people deprived of liberty. Obviously, this is a special convening of this conference during COVID, and this is a particularly important topic when we are talking about COVID. As we all know, the situation for detainees is particularly dangerous because there's little ability to social distance, access to healthcare and protective equipment is also limited. So we have a very diverse panel today, and that I'm excited to have members of the judiciary, from the prosecutor's office. We have lawyers, we have civil society members, and I think it will be an interesting discussion. So our first speaker today is Justice Sapana Pradhan Mala. She's a justice at the Supreme Court of Nepal. And Justice Mala has been on the Supreme Court since 2016, where she's also a member of the Access to Justice Commission and has been a long and very strong advocate for ensuring the right to quality legal aid representation. Justice Mala is a renowned women's rights activist in Nepal, and she's made significant contribution in legal reform on women's rights. She's the founder and president of the Forum for Women Law and Development, and we are very lucky to have her with us today. Justice Mala, the Supreme Court of Nepal has recognized the necessity that detainees be released during this crisis and has issued several strong directives. These orders direct that release hearings continue and that government should release detained persons, especially children, the elderly, people with health conditions. Can you tell us a little bit about how this was able to happen?
Talking about what helped, I think the first is like the preparatory meeting of the Supreme Court, full court itself, especially to prepare on how to manage court during this pandemics. And in that meeting, what we decided is that, which is an administrative decision, but to activate a Criminal Procedure Court and Children Act, which provides provision like suspension of sentencing of the children upon the request of the guardian for the children who are in the children home, and secondly for the people who are detainees or who are prisoners, for them if the sentence is up to 1 year, then in lieu of their sentence they can pay the cash and they can be released. So that decision really helped because with this decision the court also said we will register two kinds of cases. One is habeas corpus cases, and secondly the cases related to COVID-19. As a result, many cases came to the court, and the court started giving orders to use the appropriate provision of the law, as well as when the habeas corpus issue came, the court, when there was a direct establishment of illegal detention, the court issued a habeas corpus order as well. So with these two cases, there are many people, many children who were but in that I also have to mention one of the case which came as a PIL to the court. And this PIL was brought by the prisoners themselves, and their issue was like since there is an insufficient safety health measure taken inside the prison, and since prison is overcrowded, the government have to reduce overcrowding, deal with the overcrowding situation in the prison. And even in this case, which where the full text was given last week, the court issued a time-bound order where they even asked the government to expand the health services, ensure there is a sufficient safety health measures inside the prison, but also allocate the budget. But in addition to that, the court also said release the senior citizens and also people who are in a critical health condition, as well as children and women. But the court also said use alternative prison measures which is provided by different legislations. As a result, now we already have 600 people who have already been released. Among them, like 400 is juvenile, but the action which has to be taken under this the public interest litigation is yet to be seen, because this case was decided only a few weeks back, and the full text was given only on Thursday. Then, in short, what I would mention, what helped to bring this decision is, one is the report of Attorney General Office itself from all prison of Nepal, which indicated insufficient safety measure, overcrowd situation, and they not only share the challenge prisoners are facing, but they also suggested some measures which was really useful to analyze the risk and look into the possible solution which judgment could brought. Secondly, also the report of the Parliament Committee on State Affairs was quite helpful, and I must acknowledge at this juncture some of the report produced by UN bodies like UNODC, WHO, UNH, OSCHR, which gave clear message the threat or high risk of the prisoners. And not only that, they also have been sharing how the other countries are taking different measures, and which measures the experiences is quite useful in taking decision. Third is being party to human rights body, human rights instrument, and especially the General Recommendation 21 of Human Rights Committee was quite useful to make decision, as well as we are very proud that Nepal is also party to second protocol to ICCPR, which recommends government to abolish the death penalty. And also I must mention at this moment our own Nepali constitution and the law, because now our constitution has shifted its paradigm from retributive justice to the restorative justice. And the new criminal code which is in place has been promoting for alternative prison system, reformative punishment system. So having those law and constitution in place also helped the court to create accountability and put forward strong recommendation, strong order against the concerned stakeholder to act immediately.
Thank you, Justice Mala. You know, the orders have been very effective and very very strong in their presentation. My follow-up question for you is, how do those directives then get implemented, right? Even if the court issues great judgments and really helpful directives, we all know that the prisons don't just open up their doors and let people out, right? So what are the various roles of the people involved? In particular, what are the responsibilities of the lawyers and advocates in implementing these orders and these directives, or other various stakeholders and actors in the process?
I think even to make a certain intervention from the court, it would not have been possible until and unless the civil society, the NGOs, the pro bono lawyers who would facilitate bringing the case, representing the detainees or prisoners. I think they have contributed extensively in bringing the case itself is very important. Otherwise, until and unless sumoto action we could take, we would not have been able to make any kind of intervention. So they have been playing critical role, in fact, in creating an enabling environment for creating accountability among the responsible agency. But then I mean, your question is like how to create different actors engaged and making sure that judgment is implemented. I think you have touched upon very important question, because having judgment is not enough until and unless it is translated in the life of the people. It can be realized in the life of the people. They can use it for the justice. But then even before identifying the actors, one responsibility I think the court also has to take is giving notice of the judgment itself on time, because sometimes we take even quite a lot of time to write the full text, to give the notice about what we decided. I think that is very, very important. We notify on time, and there are two kinds of situations: when the individual cases has come, when there is a lawyer, when the parties has an interest. They have more access even for implementation, because implementing those kind of individual cases is not difficult. Once the court gives habeas corpus order or mandamus order, it is immediately implemented. And I mentioned like 600 people have been released. It is directly released. Action is taken immediately upon the court verdict by the prison management, by the police management, by the Home Ministry. But the problem is more deeper when we deal with the cases of the people whose liberties are deprived. So I'm talking about the present latest case, because they are detainees, they are prisoners. So who will take the responsibility even to follow up the implementation? That is the important questions which we need to deal. And my own experience, the previous with my previous work as a public interest litigation, we get very excited when we have a good judgment, and we think as a lawyer, as an NGO, our work is over. But my own experience says no. Now you have more responsibility to make that judgment realized in the life of those people whose rights are deprived. As a result, I can say, like, with the continuous engagement, not only like when we worked for equal inheritance right or marital rape or right to abortion, to reform the law, to put law into place, but we even worked together continuously until the rights are realized, creating access, creating services. So I think civil society has to take that role, as well as it also depends on how active the government agencies are, because in many countries, and I can share about my own experience of our own country, Nepal, where we have a judgment execution directorate, we have a judgment execution department in Attorney General office, in the cabinet, in the court itself. But having that is also not enough. What is important is that, and I would call here, especially to the civil society, and that use judgment as an advocacy tool. Identify responsible actor, monitor, give best measures, and mobilize media. Especially, I'm talking about the present judgment, which has come from the people living in a condition deprived with liberties, become their voice to protect their life. And especially in Nepal, time has come to give the message that death penalty is abolished in the country, and we cannot just be a silent observer of increased infection and how fast it is spreading. and how many people are dying in the prison. So time has come to become the voice, to translate the judgment in the life of the people, and civil society media has to take major lead.
Thank you, Your Honor. Absolutely, there's the need for all of us to come together, and there's certainly a role and responsibility, you know, amongst us all. I think it's a very opportune transition to our next speaker, who actually is from one of the government agencies who you mentioned. We are fortunate to have with us the advisor to the Attorney General on National Affairs of the Office of the Attorney General of the Islamic Republic of Afghanistan. Mr. Hussein Ramos has been the advisor to the Attorney General since 2018. He has lived most of his life in Afghanistan. However, he also studied in Canada, where he had obtained his master's and PhD. He has extensive professional experience in areas of democracy building, human rights, and justice reform, and worked for the National Democratic Institution for International Affairs, and later the Afghanistan Human Rights Commission. Mr. Ramos, thank you for being with us today. Very nice to see you. Welcome. You know, I think Afghanistan offers a very encouraging example of the Attorney General taking a leadership role in addressing the dangerous situation of overcrowding in prisons during COVID-19. Following recommendations from legal aid providers and others, President Ghani issued a decree calling for the release of up to 22,000 prisoners, and further directed that the Attorney General issue guidance on release of pretrial detainees. The Attorney General's guidance emphasizes that prosecutors should avoid detaining suspects pretrial where the law provides for their release. And I'm hoping that you can tell us a little bit about that AG guidance and how you think that will influence efforts moving forward to reduce pretrial detention rates.
Okay. Hello, I should say good morning. It's morning here in Kabul, and it should be also morning for most of you. And I should say thank you very much for including Afghanistan Attorney General representative to be also part of this conference, and especially myself. I should also say that because of a very poor internet here that we have, and you can expect from a war-torn country. So in case if my video turns off, so I will be on the audio part of it. Related to your question, Holly, I should say that as you know, Afghanistan is a country in the middle of civil war. When the news of the spread of corona hit Afghanistan public sphere, it was a kind of shocking news for the overall judiciary system in Afghanistan. And we have a high council of rule of law, which is in the presidential palace, including Attorney General of Afghanistan and Supreme Court, Ministry of Justice. So initially, we developed some initial meeting to develop the grounds for encouraging the president of Afghanistan to sign the decree on the amnesty and release of detainees and prisoners. We had more than 36,000 prisoners and detainees by that time. I mean, in February and March, that the president sent out the decrees, because the prisons were very overcrowded, and it's related to the very high rate of crimes in Afghanistan, including crime that related to war, terrorism, corruption, as well as we also have, because the country has had very low record on, unfortunately, on women's rights, and then over the recent years, Afghanistan government and especially Attorney General Office has been very tough and has developed provision and regulation in terms of addressing crimes related to violation against women. So the fear was because as underdeveloped country and as a country in the middle of war, that the overcrowd in the prison as well as in the detain centers might inflict losses over the detained in the prisons. So fortunately, in March 2020, we obtained 2 decrees from the president guiding the justice system of Afghanistan, including Attorney General, to provide an act on release of the prisoners as well as detainees, but it was not, of course, universal, and there were some certain prerequisites. I should say that, as you mentioned, of the figure of more than 20,000 prisoners were released, that's something like 10,000 of them were Taliban because they were coming from a separate deal, but over 12,000 of them were among from detainees and among from the, I should say, normal detainees and prisoners. Something like 2,000 were released on bail, and we had to develop procedures and provisions to guarantee that after after Corona is down in Afghanistan, we could have them back in the prisons, including 1,000 detainees. But at the same time, something around 8,000 prisoners were totally released, and they were part of the decree of the president. I should also mention here that women prisoners, most of them were released. So it happened that our prisons all over Afghanistan in 34 provinces, we no more had female prisoners. But the problem was, the challenging problem was mostly with detainees, because we had to stop it and postpone the investigation phase. And fortunately, we did it. And because most of the judiciary institutions were supposed to be off for a while. However, AGO, we could manage to come every day or every other day. But fortunately, we could accomplish the release of almost all detainees. There were exceptions that they were not subject to that amnesty decree of the president, and among them were the perpetrators of violation against women, terrorists, as well as people who were charged or accused of administrative corruption. I should also mention here that among the released prisoners and detainees were people who were, according to the decree, who were 55 years old, or they had very severe illnesses. So having the impression that they may lose life in prison because of being vulnerable to the corona red lines, like higher senior ages at that moment, what was a kind of red line for everybody. The same was with people with very severe illness. So we managed to release all those people. The coordination went very well between Attorney General Office, Supreme Court, Ministry of Justice. These are the 3 main institutions in Afghanistan that they should coordinate over developing new procedures, and their activity and act are very necessary to have a good justice system. It went very well, but by the way, it needed a lot of time and a lot of efforts. I should mention that Attorney General Office of Afghanistan, as a guidance to implement the decree of the president, we hired very senior official at the level of the Deputy Attorney General and head of directorate, plus 50 prosecutors every day to go to the prison and detain facilities to manage the release or the postponement of the sentences of the court. So we were very happy that that process went very well. we almost did not have any loss of the prisoners and detainees in our prisons. And it was accomplished as a success story over the crisis months of Corona in Afghanistan.
Thank you very much, Mr. Ramos. You know, there are some questions coming up, and one in particular that that I also had for you, but I think if you don't mind, just to keep things moving along, I'm going to save that question for the Q&A section and let the person who asked it join the conversation. So at this time, we will actually move on to our next speaker, who is Madhurima Dhanuka. She's the program head of Prison Reforms Program at the Commonwealth Human Rights Initiative, CHRI. She manages their initiatives to improve prison conditions and strengthen prison oversight mechanisms. They also work to strengthen pretrial decision-making and ensure prompt access to effective legal aid for persons in custody. Madhurima is a lawyer with a master's degree in criminal justice, and she has practical experience in the High Court as well. She's worked with CHRI since 2008, has published numerous studies and reports, and will actually be speaking on one of those today. So Madhurima, I understand CHRI is close to concluding a study on what some of the successful interventions have been in terms of release of detainees in India. Several tens of thousands of pretrial detainees and many convicted persons as well. I find it particularly interesting that the number of pretrial detainees is actually more than convicted prisoners, right? Because what we were just talking about a little bit is that, you know, presidential amnesties have been relatively easy mechanisms for obtaining release of prisoners. But in regards to pretrial detainees, that's a struggle that we deal with, you know, every day. And that is, I think we've been finding harder in terms of obtaining release of clients during COVID. So I'm really looking forward to hearing from you what was most successful, what were the roles that legal aid providers played, the role of the court and other actors in that process. And if you would also, you know, help us think about some long-term lessons, right, for how we take these current efforts in reducing pretrial detention beyond the pandemic situation. So thank you and welcome.
Yeah, so hi everyone, and thank you, Holly, for the question and the introduction to the work we do here. So I'll be sharing today, as you said, some of the details of the decongestion efforts that were undertaken in India. For those of you who do not know, India has the 5th highest prison population in the world. And we have around 70% unsentenced prisoners, to answer to what Holly was saying. The latest figures have made it to 70%. And when the virus first knocked on our doors in March, the Indian prisons with their 118.5% occupancy rates were at high risk. Thankfully, this did not go unnoticed, and the Supreme Court of India initiated some decongestion efforts by constitution of state-level committees. This is interesting, and I was also hearing in on how it has happened in Nepal and in other countries as well. I've been reading up. So in India, the state-level committees was supposed to decide on the eligible categories of prisoners that could be released to ease overcrowding. One of the reasons of doing it state level was because, you know, India is a huge country and the numbers are also as big. And I guess the Supreme Court wanted to, you know, the decision making to be more specific to the state of where it was happening. So the Supreme Court had also directed, in addition to these state level committees, the weekly functioning of, in India, there's a district level body called the Under Trial Review Committees, which are mandated to review cases of unsentenced prisoners. So the Supreme Court also directed them to be working weekly, which is otherwise quarterly, And they have, our research has been documenting both the functioning of the high power committees and the under-trial review committees, that is the state level and the district level committees. Interestingly, by June, and I'm still waiting for my PowerPoint to go on. I'm not sure if it's visible. Yeah, all right.
I think it's up, Madhurima.
Yeah, all right. So if you can move to the next screen. So it's just a little bit of the timeline of how this has happened. So so as I was saying, the Supreme Court took note of this. They constituted the committees, and their identification and others happened. And by June, it was reported that pursuant to these recommendations, more than 40,000 unsentenced prisoners, we call them under trials in India, and around 16,500 convict prisoners were released. The releases were by both by releases under bail and as well under parole. We didn't have anything like an amnesty or any blanket release that happened here. So while our upcoming study on this decongestion raises some points of concern, I will share them in a bit. But first, I'd like to respond to you, Holly, your question on what the role of the courts, prisons, and legal aid providers was in this effort. And if can you please move on to the next slide, please? So on the courts, as I shared earlier, it was an effort led by the Directorate of the Supreme Court with a senior judge from the High Court who was also the executive chairperson of the State Legal Services Authorities, which is the nodal legal aid body here at the state level. Being the chairperson of the committee, and the district courts continued to conduct urgent hearings virtually in most of the cases to decide bail applications. And this, of course, was one of the primary steps needed when you are talking about releasing under trial prisoners. Prisons too contributed their bit, and they assisted in the identification process. They also were implementing precautionary measures to contain the spread. The Ministry of Home Affairs came out with some detailed guidance on how to deal with arrested persons and persons in custody during this time. And they also helped, and they also helped in coordinating efforts by other stakeholders in ensuring that the applications, etc., were to be filed. However, as I was saying, while the prisons and the courts were doing their bit, but at the same time, legal representation was one of the concerns, because for under trials, you can't get bail unless an application is filed. So as I was saying earlier, so as there were no blanket releases ordered particularly for unsentenced prisoners, this meant that individual applications had to be filed for securing release. And this is where legal service providers played an important role. With the lockdown imposed from March end and restrictions on visit to prisons, the legal aid machinery bolstered its efforts and assisted in decongesting prisons in several ways. So for instance, most states...
Madhurima, I'm sorry to interrupt. Can you just slow down a little bit? I think our translators are having a hard time.
Okay. All right. Yeah. So so as I was saying, during when the lockdown was imposed in India, that's in March end, the visits to prisons had also stopped. And that meant that lawyers, private lawyers, did not have access to prisoners, and the efforts by the committees would have failed had there been no mechanism to file applications in courts. So it was here when the legal services providers continued to access prisons and prisoners either physically or virtually. There were some guidelines that had been laid down by NALSA, which is the National Legal Services Authority, kind of just directing what kind of precautionary measures they should be using while they're going inside prisons or when they're interacting with prisoners. Panel lawyers and paralegals assisted in preparing the list of eligible prisoners. They also assisted in filing applications for release in courts, as well as for releases on parole as well. And we've also got some reported instances which are coming out from our research, is where the legal services institutions also assisted in providing ration, which is just some basic material upon the release of the prisoners, given it was a lockdown, and also transport. Because one of the biggest hurdles that appeared to before us was the fact that if you release a prisoner and the public transport and everything else is in lockdown, what would happen then? So thankfully, the legal service authorities actually did, they did commendable work in this regard, and they have actually provided and ensure that prisoners who are being released, and I'm saying for some districts, I wouldn't say it true for all the districts here. So the figures, if you can see, the figures indicate that during this period, assistance was provided in more than 45,000 cases, which itself is quite commendable.
I think we may have lost Madarima. Or is that just me? Sorry, Rachel, are you frozen? Can you exit that screen or? Okay. Thank you. Madarima, did we lose you?
Sorry. Yes, I guess something happened with the internet here. Sorry.
Okay, no problem. But I do have to ask you to, you have a couple minutes left, and I'm happy to give that to you, but you do have to speak very slowly. Try to speak as slowly as possible. Thanks.
Yeah, absolutely. Yeah. Can I have my presentation back on? And meanwhile, I'll continue. So as I was saying, the legal service authorities were very valuable in terms of trying to put together the applications and ensuring that they get heard and filing them in court, etc., which also needed process. And there was also a process to get for releasing under trials, you need to file surety, etc. And there are reports of where that assistance was also provided. I do want to share also briefly what work CHR has done during this period. We've been preparing a lot of guidance notes and documents for assisting in this task, and we've been tracking releases of prisoners. We've tracked the number of positive cases now, which is somewhere around 9,000 as of today of both prisoners and prison staff. And given in percentage wise, it's quite less from how the country is faring, but there is a huge risk that these numbers are going to really grow a lot in the coming time. And we've also been convening with CFSOs and etc. So we've been kind of busy and on our toes trying to respond to these, and now we're doing these studies to document how this happened, because we feel there's a lot of learning that would actually come out from here. Some of the flaws that I talked about, I'd quickly share those as well. So some of the flaws is that the committees didn't really function in a very uniform manner. And that meant that not every state saw the number of releases that it could possibly do. Some states were quite liberal. Some kind of refused to release anyone, saying they don't have overcrowding, which is probably not true. And there's another concern was that while the releases were happening, the admissions continue to happen simultaneously. There was a lot of, there were a lot of arrests due to lockdown violations, etc. And our research is now, like the preliminary research seems to indicate that the number of releases was actually less and the number of admissions have been higher. We'll have to wait till we actually finally finish it, but this would be quite ironical if that is the situation. Nonetheless, I'll answer now your last question, which was on the long-term lessons. So I think the first lesson here, and I think it's true for everywhere in the world, is that decongestion is possible. It is not that you didn't need to have a pandemic to do these initiatives. They could have happened even otherwise, and maybe with less trouble as well. So coordinated efforts can definitely lead to reduced prison populations. And it does, we can actually have these as a regular exercise. Why do it only when there's a public health crisis? You could just do it all the time. And I think the other thing that has come out of this is the spotlight has emerged on the prison conditions and inadequate healthcare. And, I think that's again, there's been a lot of reiteration over the past few months on, using pretrial detention as a last resort. But the realities are that pretrial detention rates just keep on increasing. And in India, I've just seen it's gone from 60 to 70, and they just keep on increasing no matter what the efforts are. So probably there needs to be a lot more that, we do. And I think that's the next question. And I think that's something that probably we like to see in the outcome document is, where do we come in, and what is our role? And as just as Sapna said, that, you know, the role of civil society here, I feel, is very important. And practitioners in particularly, I think right now, even to understand, to document what the impact of COVID-19 was in prisons, the decongestion efforts by different countries, and I think the role of legal representation as well as legal service providers is very important, I think, to the entire process. As we saw in India, I think if you would have cut out the legal aid process here, then probably there would have been a lot far less releases that would have happened. And I think, you know, I think documentation to me does sound to be something very vital, because it not only provides useful information and good practices, but it enhances our own understanding of, you know, what are the long-term impacts, where do we go from here, what do we need to do. So yeah, on that note, I'm going to end. Thanks.
Thank you, Madhurima. Yeah, I agree. I mean,
Okay. Hi, everybody. I'm Trisha. I'm Program Director at the International Legal Foundation, and I'm happy to step in and continue things on while Holly seems to have had some sort of technical difficulties. So thank you for that presentation, Madhurima. I just ask all future speakers to try and speak as slowly as possible, because there are issues with the translation, which is not entirely the fault of speakers. Certainly there's also a lag and delay and that sort of thing. So just keep that in mind, bearing in mind that obviously we also have time limits as well. So thank you again, Madhurima. We'll move on to Mr. Cedric Foussard now. So Cedric is an expert on justice for children, having worked at the international level for some time now. He's currently coordinator of the Global Initiative on Justice with Children, and is Advocacy and Global Learning Senior Advisor for Terra de Homes Foundation. For more than a decade, he was the director of the International Juvenile Justice Observatory, which is an international not-for-profit organisation that promotes a global approach to child's rights, especially for children in conflict with the law. He's contributed to several international and European publications on access to justice for children. So Cedric, thank you so much for joining us and speaking with me today about the campaign on accelerating the release of children from detention around the world during the COVID crisis that we're all experiencing. Even though the campaign is not Asia specific, we really believe that you will have some valuable insights on best practices in various contexts, and some advice on what advocates everywhere can do to get kids released. So thank you, Cedric.
Thank you very much, Trisha. I hope you can hear me very well. Thank you for saying that I've been working for a long time. I feel quite old now, and it's quite early morning here, so I feel old and tired. But I will do my best to share with you what we've done at Terre des Hommes. Terre des Hommes is a Swiss organization. We're working in 45 countries, more or less. And last year, we managed to help more than 2 million children and their families around the world in emergency crisis or in a more programmatic areas such as health, justice, care, migration, etc. So as most of you, since end of February, beginning of March this year, we've been in lockdown, and we try to benefit from this extra time without traveling to work on a global campaign, as you say, Trisha, to accelerate the release of children deprived of liberty in time of pandemic. So we did this campaign with the pro bono department of the law firm Baker McKenzie, which is an international law firm based in several countries all over the world. And we decided to recall the situation of children in detention, and in particular at that time, in time of pandemic, recall the international rules, but to focus on practices. So this is why we draft this police and practice recommendation for professional and policymakers. So, as the previous speakers said, mainly about adults, but it applies for children as well. COVID protection and preventive measures are very difficult to put into place in a closed environment of deprivation of liberty. As you know, social distancing is almost impossible in overcrowded institutions. Sometimes health, basic health like sanitary is almost impossible due to the lack of access to water. And we, of course, found that there is significant risk for children in detention in this time. So there is different kind of risk. Of course, the first one is a physical health risk for children, mainly because children in detention all over the world may suffer of other illness and often serious illness, which can be linked to difficult life, drug abuse, or other kind of health problems. So they are certainly in a greater risk than children who are not in detention due to the situation and the structure by itself of the institution where they are deprived of liberty. Of course, as you can imagine, there is a risk on the mental health of children. We saw several problems all over the world of children having the COVID-19 and being put into solitary confinement, which is a double victimization. They are in solitary confinement, they got the COVID, and they are certainly at risk of developing a serious aspect of the illness. But we found as well in a lot of countries that, of course, the COVID is putting a lot of strains on detention center by itself, on the administration, on the workers, on the security forces working in there, and even on other kind of services. So to give you an example, a company in charge of food delivery in UK was trying to stop delivering food in detention center to protect their own and employees, but that bring, of course, a lot of risk on the kids being detained. And of course, as you can imagine, detention could be the focal point or the center of a new cluster. And so it's as well a risk for the community. So bringing this situation and the international standards focusing on deprivation of liberty for children as a last resort and for the shorter period of time, and all the different articles of the Convention of the Rights of the Child, as well as the international instruments, we decided to have a look into the practice in the different countries. Mainly we start with our colleagues on the field in terrorism. Delegation all over the world. And we found several levels of practices that we found interesting and that we are stressing on this policy and practice reports that we produce. So first, there was a strong effort to release children from detention, those who are actually in detention. The first exercise was to focus mainly on children in pretrial detention, as well as children who are finishing their sentences. And TEDism managed to work in several countries, like in Afghanistan, where 127 children been released by mid-May last year. In Iraq, we developed some emergency release before summer, as well as in Mali, where we focus in pretrial detention. Then another set of recommendation and practice that we have identified is to limit the placement of children in custody. So that means to invest in community-based sanction, in diversionary measures, and of course in alternative to deprivation of liberty. So for instance, in Asia, terrorism been working in Myanmar in the province of Yangon and Mandalay to develop diversionary measures in the community to be sure that children will be not sent to institutions. Then for the facility which remain open, and children will stay in facilities, the idea was to develop with the authorities protocols to reduce the risk of virus spreading. So those protocols could have been to distribute hygiene products, for instance, in Afghanistan, in Iraq, or as well to work with the authorities and social services in some cities like Guayaquil in Ecuador, to be sure that children will be protected within the detention institution, while actually outside in town, the virus was spreading everywhere. And then finally, the last point that we developed, and there is, of course, is much more developed in the report that I encourage you to read, is to ensure the mental health of children. So for this, there is several possibilities. The first one is, of course, to continue facilitating the visits of the families, which is difficult, of course, by respecting social distancing, but some countries have been implementing practices to be able to do so, like we did in Burkina Faso, for instance. And then to invest in technology to allow phone call, video, Skype call, etc., with the families, and even with the legal institution, like the court, to continue the process. No, it's what we managed to do with Jordanian authorities. But just as a conclusion for this, I will say, Tricia, that I really like what Madhurima say before in a long-term recommendation or practice. She found that decongestion is possible. Decongestion, sorry, is a difficult word, is possible, and it's what we found. We found that actually by putting effort on the different professional and in the institution, we can actually easily find new ways of dealing on child justice.
Thank you, Cedric, and also thank you for Tricia for stepping in. Of course, you know, the technical difficulty happens right in the middle of the panel. So thanks for all of your patience. Cedric, I was thankfully able to catch your presentation, and a couple of very interesting points, you know, have come up, and some questions too regarding the technology piece. And so maybe during the question and answer session, some of us can speak to that. You know, I do think that you were speaking maybe more about technology in detention centers, right? To speak to clients and children who are being detained. Obviously, there's also the question of technology around virtual hearings and continuation of trials remotely. Also, you noted obviously your report, and so I did just want to say to any of the panelists, if you all have links to these reports that you're talking about, please do share those in the chat with our participants, and we can also follow up afterwards, you know, if anybody needs further help accessing these really important reports and studies. So moving on to our final speaker. So we should still have some time for Q&A afterwards. Ms. Maite Deru is a policy officer at Open Society Justice Initiative, where she works with the litigation team and has more than 20 years of experience working as a lawyer specializing in human rights, criminal justice, and detention issues. Prior to joining the Justice Initiative, she was deputy to the Prosecutor General in Belgium, and she was also the first vice president of the European Committee for the Prevention of Torture, which visited places of detention to see how persons deprived of their liberty are treated. She's also has previously served as an advisor to the Belgian government on justice and migration issues, and as the director of the Belgian Association for Human Rights. Maite, thank you for being with us today. You know, the other panelists have primarily been speaking about process and roles, arguments, and advocacy that we can make to get people out of detention during COVID. But as we all know, the fact is that, you know, there are going to be many clients and many people who we cannot obtain release for. And so OSJI has recently published a very insightful brief about how to litigate to protect the rights of clients who are in detention. And specifically during COVID, the right to healthcare. So I'm grateful if you can give us an overview and provide some guidance on how we can mobilize international law to this end. So over to you.
Thank you very much, Holly, and good morning or good afternoon, everyone. It's really super interesting to be part of this panel. So, as Holly said, I will focus more on the situation of the people who are staying in prison, who remain imprisoned during this pandemic. So we all agree, including within the Justice Initiative, that the first obligation that relies on state is to create healthy and human conditions of detention, and that as a consequence, the first duty they have is to make sure that there is no such overcrowding as we observe all around the world, and the first obligation is to release a certain number of prisoners, or make sure that not as many prisoners do enter in prison. But with the Justice Initiative, we were also concerned of the situation of those remaining in prison, because we know that there will still be prisoners in the prison during the pandemic. And so we looked at international law to try to understand what we can learn from international law. And the legal brief we have published, and I will share the link in the chat right after. So this legal brief highlights that two main lessons can be learned from international law regarding COVID pandemic and access to healthcare in prison. The first lesson is that international law imposes to states to guarantee access to healthcare in prison, especially since states have the duty to protect life of prisoners and also to make sure that they are protected from the prohibition of torture and inhuman treatment. The second lesson is that international law allows to define the specific measures authorities must take to protect life and health of prisoners during a pandemic such as the one we are living. In other words, there is no need for new regulation in order to define states' obligation. So, drawing on international standards, such as, for example, the Nelson Mandela rules, but also regional standards from different systems, Latin America, Council of Europe, Africa system, we have identified 4 areas where measures must be implemented in prisons during the pandemic in order to protect the health of prisoners. These 4 areas are preventive medicine, access to treatment and medication, the issue of isolation of prisoners, and also what to be done when a death occurs in custody. So I will very briefly detail these 4 areas, but first I would like to underscore that all measures must be developed taking into account 2 realities. The first is that prison populations have very specific needs, since they are often, prisoners are often in poor health situation. even before being incarcerated. And the second reality is that the current crisis has deepened inequalities, including in prisons, and there is then a need to identify and support the most vulnerable people within prisons. So moving to these four areas I identified, and there would be much more to say than what I'm going to say, but I will refer to you to the legal brief. So first, preventive medicine. The first lessons to be learned from the international law is that providing healthcare in prison is not limited to treat sick prisoners. On the contrary, states' obligations include this obligation to take preventive measures. Health service must, and I'm quoting UN standards, health services must evaluate, promote, protect, and improve the health of prisoners. Connecting connecting these general standards to COVID pandemic, we could identify at least 4 measures that states have to take and to implement into the prisons. First is that staff, prisoners, and visitors should receive all relevant information about the disease and how to be protected from the disease. Second is that detainees must receive adequate products in order to maintain both their personal hygiene and their environmental clean and safe, which means having access to what is critical during regarding COVID-19. So water and soap to wash their hands, and also cleaning products to keep all their facilities clean and safe, and also especially the facilities they have to share with other detainees, such as, for example, sanitary facilities, or even the phone they are using in the prison. Third, detainees and staff should be provided with personal protective equipment, meaning, for example, masks. And fourth measure is organizing testing within prisons, both for prisoners entering the prison and prisoners during testing of prisoners during detention. This is a very, very complex issue, testing in prison, and we have tried to provide some guidance in the legal brief. And a final word on this preventive medicine area is that this tools, products, testing, etc., masks that should be provided to detainees should be provided free of charge as part of, access to healthcare. Second area is the access to treatment and medication. Basically, prisoners should have prompt access to adequate care, which means diagnosis, adequate treatment, proper monitoring of the administration of treatment, and when required, prompt transfer to hospital. In that last regard, the WHO has underscored that there is a need for relevant authorities to develop protocols with large communities and with hospitals in the community to know which have the capacity to host patients, and also to define clear criteria to determine when to transfer a sick prisoner to the hospital. The third area we developed in the legal brief is the issue of isolation of prisoners during the pandemic. We know that highly contagious diseases such as COVID-19 requires to isolate infected prisoners or prisoners who could be infected to protect other people. But on the other hand, and Cédric has underlined also this, authorities must have in mind the very well-known damaging effects that prolonged solitary confinement has on the mental and physical health of prisoners. To find the right balance between these two requirements, international law provides some guidelines, and I can highlight 3 of them. First is that isolation should exclusively be decided by medical staff and for medical reasons. And in the context of pandemic, the current pandemic, WHO has underlined that that newly arrived prisoners should not be systematically isolated from others, given the disproportionate effect it can have on their health. Second guidance is that isolation should not be maintained for a period longer than medically required. And third is that even when isolated, prisoners should keep and be maintain meaningful contacts every day, and also should have, be adequately monitored and supervised by medical staff. My last point.
Maite, yeah, you may have to refer people to your brief on the last point, unless you can be very, very short on it.
30 seconds.
Great.
30 seconds. It's about the duty to investigate in custody. And thank you for giving me a few seconds to highlight this, because it's a very important issue too, because we know that people have died from COVID-19 in prison. And just to remind the basic international rules that every single death in custody or in a hospital right after a transfer should be properly investigated by an independent authority to understand the causes of death and to identify the possible responsibilities, and to learn the lesson and implement new rules in prison to avoid other deaths in custody. Thank you very much, Holly.
Thank you, Maite, and thank you to all of the speakers. I apologize. I think with some technical difficulties, we are, of course, running a little bit over, but we do have some time for question and answer. I would like to still try to allow the participants to voice their own questions. Hopefully that's okay with our tech support. I referred earlier to a question from Chi Su in Myanmar. So Chi Su, if you're still with us, if you can raise your hand, then the tech support can unmute you. And in particular, the question that you had for Mr. Ramos from the Attorney General's office in Afghanistan was the question that I was thinking of.
Hello.
Hi, Chisu, we can hear you.
Hi, Holly. Thank you for giving me the opportunity to give my voice, and thank you all the panelists today. So my first question is about the rule of law. So during this COVID-19 pandemic in Myanmar, we also had a presidential amnesty. And at that time, the public opinion on the rule of law, so the amnesty process also affected the public's opinion on the rule of law. So as an Attorney General, I wanted to know what was your reflection on this.
That's great. Thank you. Thank you, Chisu. Mr. Ramos, if you are still with us, this is directed to you, and the perspective from the prosecution side, right, and the Attorney General side. How did you deal with that challenge?
Thank you, Chisu, for your very meaningful question. We all know that the pandemic of COVID-19 was something very surprising and unexpected for almost every judiciary system in the world. I should say in Afghanistan, the case is even more complicated because we are in the middle of war. We are having also prisoners or detained people from opposition military groups such as terrorism or narcotic cases. And certainly the release or amnesty or postponement of trial was something a very concerning issue for Afghanistan public opinion, and we had to decide everything simultaneously. The deciding about addressing the damages of the COVID-19 on people as well as on the prisoners. The good thing was that we were already prepared in terms of very intensive reform over the judiciary system, and we were in a very good concert of efforts with civil society and media in Afghanistan. And media was very active to downgrade the concerns of people that addressing, a timely addressing to the crisis did not mean that we are not hard on crimes and criminal in Afghanistan. But this was a time that we had to remedy the losses of prisoners and people that, according to human rights norm, this was the responsibility of Afghanistan government and judiciary system. I should also admit that fortunately, despite all those internal political crises in Afghanistan because of them having military opposition, because it was kindly shocking for the people, and whatever we were doing in terms of addressing the prisoner release or amnesty or postponement of sentences, fortunately we didn't have much concern from the public opinion, but it was after, when we had lower surge of COVID-19, that Afghanistan, I should say that we are in a good shape in terms of response to COVID-19. We do not have a lot of losses and we do not have a lot of cases, but fortunately it has been perceived very well. But the media and civil society, because they were bridging in those quarantine days and months, they were bridging us to the people, and we could convince the public opinion that it is true that crime is a concern of everybody in Afghanistan, but at the same time, we are responsible for the life of people. But we have also long-term plans that we would bring back people who were released on bail. They will be back, and we have enough measures not let anybody to escape law and rule of law, but this is only a short period of time response. Fortunately, we had the people with us because we could easily shape this, and the decrease of the president was announced also through media and national TVs, so people were ready for that. I should also say that we are in the middle of a big reconciliation phase at this stage, as well as with Taliban and with those military groups, that the amnesty to some of their prisoners was also a prerequisite. So these things have been kind of combined in the same time, and fortunately we are the safe side in terms of convincing public opinion. Thank you.
Thank you. Thank you, Mr. Ramos. Thank you, Chisu, for your question. I think we're going to try to turn to a participant from, I believe, from Afghanistan. Is it Ahmad Rafi Nadiri? If you can raise your hand. And if you could please, I think you have a couple of questions, both related to online hearings. And as far as the panelists go, whoever wants to respond maybe can raise their hand, and we'll try and give you the floor. So, Mr. Nadiri, are you? Do we have you? Okay, no. Mr. Nadiri, are you there? Here, maybe I can, I guess I can't unmute you. I'm showing that you're still muted. Okay. Well, how about then, let's see. I think there was another question regarding online hearings from Amrita Paul. If you are there, Amrita, and can raise your hand. Amrita, are you there? Okay, yeah. You should be there. Yeah. Great.
Hi, Holly. Hi, everyone. This question has some sort of a background. I mean, I've been speaking to a lot of lawyers. I've been following what's really happening with the jail legal aid clinics. We have legal aid clinics in prisons. They are called JLACs, and that's why I've put them in parentheses in the question as well. My question is, on the judicial front, everybody across the world, we are all thinking about going virtual. In India, the two states, the state of Kerala, because they are actually very high on their HDI from the huge country of India, and some districts in MP. Madhurima has actually helped them to work on documentation as well. But my question is, when on average in a country as big as India, the access to technology or the penetration, internet penetration, it stands at 36%. Well, Delhi being the capital, and it stands at 69%, and a state on the eastern part is at 25%. Is virtual legal aid clinic the go-ahead? If it is, if that is the alternate, will that be a way to restart the legal aid clinics in prison, where in a lot of prisons across the country, and we have 1,400 plus prisons in the country, are there paralegals to actually handle the technology at the other end from prisons? Is that a sustainable way to go ahead? Because you do have safety concerns, and when we do not know when the virus will actually go away. And on the other hand, these conversations through the virtual legal aid clinics are in the nature of client and lawyer conversations, and they need to be confidential as well, and which will finally translate into litigations. And we are still coming around the notion of virtual courts. We still need, at least in our country, we still need to understand what works and what doesn't work. I would like to hear from panelists what can be the way ahead. Is going virtual the way around, or do we need to take it, do we need to resort to that solution because that is the only solution at hand right now?
Right, thank you, Amrita. I'm sorry to cut you off, but we are reaching the end of our session. And as I said, I do think that this issue is really obviously very important for all of us and will be a continuing theme throughout the conference. So I would just ask the panelists if any of you have a few comments on online hearings or virtual legal aid clinics, so virtual representation, right? And that lawyer-client relationship, possibly also with detention, because that's the theme of today. But if you could keep your comments very short so that we can have a few minutes to wrap up. Cedric, go ahead.
Very short. I will just answer by an example. I know that in several countries I've been trying to do so, but the example I will give, it's in Yucatan in Mexico, where actually they manage without too much technology, to be fair, but what they did in the equivalent of the court, or the Supreme Court there, they had the video connection, and then in the different local area, the audience was or at the police station or at the local court or in some public offices. So they try to do so mainly for those very non-serious cases to start with, and to avoid pretrial detention mainly, and to accelerate the judgment and facilitate measures of reintegration or measures in the community. And actually work quite well. I will be happy to make the link if it could be useful.
Absolutely, that's a link definitely worth sharing, particularly around the pre-trial detention hearings, right? Those in the face of court closures, still have to somehow continue, right? How can you get people out if you can't get in front of a judge? And I know there's also challenges with clients not being brought to court, right? And so judges saying, well, I can't release your client if they're not here. And so thinking creatively about how to respond to those issues and make applications even in the absence of your client, right? And usually there are provisions that allow people to do that. Madhuri, are you, yeah, go for it.
Yeah, so, and I'll be slow this time. So one of the things I just like to comment on is that, so we've, as Amrita said, we've been trying to follow what's happening on remote hearings worldwide. And one of the biggest concerns to flag here is that the convenience of virtual courts is kind of trumping over any discussions around the rights of accused persons and also victims to that matter. And I think that's what is very worrisome. And that's something that I think all of us as a collective can probably address, is the rights of accused persons, their interaction with the lawyer, the confidentiality with lawyers. There are so many smaller elements that seem to be missing the conversation. For instance, in India, there's an interim report that has been tabled in the parliament on virtual courts. Not even once it mentions about rights and, or safeguards. And I think that is really worrisome. And that's the trend that I've been following that's happening in other countries of the world as well. So that I wanted to flag, is that the rights-based perspective is just missing.
Yeah, thank you. Okay, so with that, again, this is a conversation. This is panel 1. We are officially reaching the close of our first panel for this week-long conference. Thank you again to all of our panelists, and big thanks to all of our participants as well. I hope to see you all again at other conferences later this week. I did want to take a few minutes just to summarize a bit of the key takeaways from this session. As was mentioned in the opening session yesterday, we are going to be creating an outcome document from this conference that will serve as a call to action for all of us. And so we are going to be compiling some of these key takeaways from all of the various sessions around the world to come together and build consensus around what we can do to move forward to increase access to justice, not only now during COVID, but beyond, right? And so I would say that for me, some of the major themes, some of the ideas that were repeated today in this session have to do with the importance of collaboration and coordination, right? We were lucky enough to have a very broad range of panelists today speaking about the kind of different roles of the various actors in this process. And so, I think also, obviously, as an international conference, and this highlights what we can learn from this dialogue, right? And this conversation amongst the various practitioners from around the world. We do have different contexts, right? We have different legal systems in some places. We have different laws on the books, but the challenges often are the same, and certainly the goals are the same. And it's so important for us all to come together and share those best practices. We don't all have to reinvent the wheel every time we're trying to get one of our juvenile clients out of pretrial detention, right? This is a shared challenge for us all, and we have a lot to learn from each other. And I think some kind of international legal aid network where we can come together as practitioners to not only to support each other and learn from each other, you know, but also to make our work more effective and more efficient, right? We all know this is hard work. There's an endless amount of work to be done. And so the more that we can help each other in that process, the better, I think. And in that regard, I would like to call us all to action, and I hope that we can agree in this outcome document and in moving forward from this panel to draft, to actually make a practitioner's guide, a legal aid handbook on obtaining and arguing and advocating for pretrial release of clients now during COVID and always, right? You know, from a rights-based perspective, as Madhurima was talking about, right? We are talking about fundamental rights here of the criminally accused, anybody who stands to lose their liberty. There are fundamental rights to be presumed innocent, to have access to a lawyer. Obviously now during COVID, the right to health and the right to life. And these are all arguments that we can be sharing. So I hope that we can agree to make some kind of practical tool out of this, and we can get together any interested legal aid practitioners to have a kind of drafting committee for this guidance tool. And then finally, the last note, and again, this is just the start of this conversation, I think, but this idea of technology, right, and virtual hearings, and also hopefully making some kind of guidance document around that as well, that we can come to some kind of international consensus around what are the bare minimums to protect the rights of individuals in the process, you know, without sacrificing the health and the necessity, right, of actually having to move some of these hearings and processes online and virtually. So that is it. I'm a couple minutes over, but I think we all did pretty good about keeping to time today. So again, thank you for that. I believe everything has been shared in the chat. This session has been recorded and will be uploaded to the conference website, although I believe it may take a couple of days for that to happen. I will leave it at that. Have a good day, everybody. It's good night for me, finally, from New York. And we'll see you again soon.